Good morning. It's 9 a.m. on Friday, May 1st, 2026. We're here on various matters in case number 26-90103, Sachs Global Enterprises, LLC. So why don't we get appearances of counsel and then we can proceed.
Good morning, Your Honor. Deborah Sinclair, Wilkie, Farr & Gallagher on behalf of the Global Debtor.
Good morning.
Good morning, Your Honor. Bob Britton, Paul Weiss, on behalf of the DIP lenders. I'm joined on the screen by my partner, Chris Hopkins.
Good morning.
Good morning, Your Honor. Lorenzo Marinuzzi, Morrison and Forster on behalf of the Official Committee of Unsecured Creditors.
Good morning.
Good morning, Your Honor. This is Michael Reardon on behalf of the SO5 Digital Debtors.
Good morning.
Good morning, Your Honor. Jerry Lee Miller from Sidley Austin on behalf of Simon Property Group.
Good morning.
Good morning, Your Honor. Amine Bordy of Sidley Austin on behalf of Exonic and related entities.
Good morning. All right, does anyone else wish to make an appearance? All right, Ms. Sinclair.
Yes, Your Honor. Good morning, Your Honor. Again, for the record, Deborah Sinclair, Wilkie, Farr & Gallagher for the Global Debtors. Your Honor, we are here to seek conditional approval of the disclosure statement for the joint Chapter 11 plan of Sachs Global Holdings, LLC, and its affiliated Global Debtors. Before we get into the substance of the disclosure statement, I just want to thank Your Honor for accommodating us this morning. I know we filed the proposed documentation just a few hours before the start of the hearing, but the good news is that the vast majority of the changes you'll see in the documents are intended to reflect the deal that we announced on the record last week with the I'm getting a lot of background noise. I don't know if you're all again.
Yeah, we have, a lot of people on. So I'm going to activate the hand-raising feature, so hit 5* one time.
Conference muted.
All right, I think you're back on.
Yes, Your Honor. Can you hear me?
I can.
Great. So as I was saying, most of the changes you'll see in the documents that we filed on the docket are intended to reflect the deal we discussed at our last hearing, which again is a global settlement among the global debtors, the ad hoc group, and the official committee of unsecured creditors. We have also, since our initial filing of the disclosure statement, resolved all other formal and informal comments that we received from parties in interest in the case. So we expect that we really are proceeding here on a consensual basis today. And before I walk through the changes to the documents, Your Honor, I'd like to note that the settlement really marks a critical achievement for the global debtors. Assuming Your Honor is ready to approve our disclosure statement on a conditional basis, Sachs Global would be ready to start soliciting creditor votes on a Chapter 11 plan of reorganization. And in light of the settlement with the UCC and our restructuring support agreement, we'll be commencing that plan solicitation with the support of our ad hoc group and the official committee of unsecured creditors, which is a key step along our path to emergence this summer. I want to note quickly, Your Honor, that the documents do remain subject to the review of the ad hoc group and the UCC, as well as the company. We're expecting to make some non-material changes to the docs that we do not collectively believe will require us to come back before the court. As you probably have surmised, we were working overnight with the UCC and the ad hoc group to get the documents as far as we could for this morning's hearing, and we wanted to give people time to get before their clients, given that we were putting the finishing touches on things at an extremely late hour. So that's the reason that you see that disclaimer at the top of the docs. But again, we don't think any of those changes will be material. We're anticipating finalizing everything early this evening so that we can meet Stretto's internal deadlines to get our solicitation commenced no later than Monday, May 4th, as is reflected in the proposed order. With that, Your Honor, I would propose that we move into the presentation of the disclosure statement, which was filed at docket number 2163.
Right, before you do that,
disclosure.
Ms. Sinclair, before you do that, does anyone else wish to be heard by way of, in essence, an opening statement? Just let me just pause for a minute. Ms. Bordy, did you hit 5-star? Your hand's raised. Did you hit 5-star?
Your Honor, I did make hit 5-star. I just wanted to make a statement at the end.
At the end,
So I
okay.
just wanted to be unmuted at that time. Thank you.
All right, good. All right, I guess there's no statement, so. Ms. Miller, are you here for the disclosure statement or for the status conference? Just hit 5-star one time. No, I don't see you. There you go. All right, I think I just unmuted you.
Thank you, Your Honor. Can you hear me?
I can hear you, yes.
Your Honor, I did have one brief comment just to make with respect to the status conference. Happy to make it after the disclosure statement or before at your preference.
Okay, I mean, either way. So let's go forward with the disclosure statement, and then we'll come back to that.
Sounds good, Your Honor. Thank you.
All right. Go ahead, Ms. Sinclair.
Yes, Your Honor. So I think the easiest way to do this might be for me to explain the material terms of the global settlement so that Your Honor understands the lay of the land, and then we can walk through at a very high level the substantive changes to the disclosure statement, if it pleases the Court.
Right. Go ahead.
The key element of the settlement that we've reached with the ad hoc group and the unsecured creditors is the establishment of a litigation trust. It'll be administered by a trust administrator that is selected by the UCC with the reasonable consent of the required consenting DIP term loan lenders. That trustee will be empowered to investigate, litigate, and settle claims on behalf of the trust with the goal of obtaining recoveries for the beneficiaries. In terms of the trust funding, the trust is slated to receive $20 million in cash on the effective date from the global debtors. That will be repaid to the global debtors from the proceeds of any litigation trust assets subject to a 1 times multiple on invested capital. In terms of the trust assets, the litigation trust will receive all causes of action that are not otherwise retained by the global debtors or released under the plan. As for the allocation of the trust assets, the Class A trust interest will be distributed to holders of both the DIP term loan claims and the pre-petition secured obligations, while the Class B trust interest will be distributed to holders of general unsecured claims, with any further, sub-allocation of those Class B interests to be determined by the official committee of unsecured creditors in consultation with the company. The trust proceeds will be distributed as follows. First, to repay the initial funding, as I just mentioned. Second, after that repayment is made, the Class A and Class B interest share all proceeds 50-50 until $80 million of proceeds in the aggregate have been recovered. And then after that initial distribution and after that $80 million in proceeds is recovered, Class A beneficiaries would receive 80% of any subsequent proceeds, while the Class B beneficiaries would receive the remaining 20% of any such proceeds. Just a few other things I think are important to note on the settlement. First, in connection with the settlement, the parties have agreed upon the terms of the releases and exculpation that are reflected in the most recently filed version of the plan. Second, the plan now separately classifies go-forward trade claims. Those holders are anticipated to receive both litigation trust Class B interest as well as a pro rata share of a supplemental cash pool. And finally, as a key term of the settlement, Your Honor, the UCC must immediately cease incurring fees and expenses in connection with the ongoing investigation, subject to some limited exceptions for ongoing discovery matters. Of course, the creditors committee has agreed to support the plan and the disclosure statement on these terms, and to recommend that all general unsecured creditors vote in favor of the plan. With that, Your Honor, unless you have questions about the settlement, I propose that I do a high-level walkthrough of the red line, and to the extent Your Honor has questions about specific provisions, I can address those.
No, go ahead. I did have a chance to review the red lines this morning. But go ahead.
Excellent, Your Honor. So I'll be quick then. Starting at the top, on page 2, we built in a clear recommendation from the debtors, the ad hoc group, and the UCC that creditors vote in favor of the plan by the proposed voting deadline of June 1. Following that, we made a handful of updates about the company's progress with brands, including that since the petition date, nearly 720 brands have resumed shipping to the debtors, and more than 320 brands have either agreed or near reaching an agreement on go-forward trade terms. In the FAQ section, which covers roughly pages 9 through 32 of the red line, there are a number of changes intended to account for the final plan classification scheme, the proposed treatment of creditors, and again, a summary of the terms of the settlement we just described. Following that, Your Honor, we then added, and I think this really takes us through about page 60, we've added a handful of updates about motions and other case developments that have all largely been before Your Honor. On pages 57 through 58, I'll take a minute here because I think it's important. We've added a disclosure from counsel of the special committee regarding the special committee's work on the company's restructuring and their independent investigation into any claims or causes of action that should be preserved by the debtors. The work the special committee has done thus far, and this is reflected in the DS insert, it does serve as the basis for the proposed releases in the plan and the scope of the retained causes of action in the litigation trust. On page 61, we similarly included a disclosure regarding the UCC's investigation, which we've also obviously taken into account in the terms of our global settlement. Your Honor, for the balance of the changes to the document, I think I would just put them into a few categories. One is filling in placeholders and making cleanup changes to the plan treatment section, which previously had some blanks. We've added the exhibits, the liquidation analysis, the valuation, and the projections. We've updated our tax disclosures to reflect the UCC settlement. We've removed the concept of a plan administrator and inserted all of the key terms around the litigation trust, again, reflecting the terms of the settlement we just talked about. We have incorporated comments from the indenture trustees around cancellation of the securities documentation and their fees and expenses. We've reflected the committee settlement in the modifications and amendments section, and we have inserted language requested by the debtor surety bond providers and the PBGC, which we agreed upon with each of those respective parties. So unless Your Honor has any questions, the debtors submit that the disclosure statement contains adequate information within the meaning of Section 1105 and request that you approve the DS on a conditional basis today.
All right. Does anyone else wish to be heard?
Your Honor, if I may be heard, Lorenzo Marinuzzi, Morrison, and Forster on behalf of the UCC. I think Ms. Sinclair's fortunately succinct presentation on the disclosure statement doesn't accurately convey the amount of work that went into getting here and the, I won't say excruciating, but pretty agonizing late-night discussions over the settlement, which is now incorporated into the disclosure statement. We did finish our discussions, as Your Honor notes, from the timing of the filing of the revised plan of disclosure statement well into the night. We've all got clients that have to have an opportunity to review what it is that we're putting in front of them, although we've been keeping them up to speed generally on the open points over the course of the past several weeks that we've been negotiating to get to this point. We expect everything will be fine, but as Ms. Sinclair said, there might be some changes that we're going to work through, and we will do a great job, as we've done to get here, to finalize the plan documents so that they can get filed today.
All right. Anyone else? All right, thank you. I did have an opportunity, as I indicated, to review the red lines this morning of the revised plan disclosure statement, and I think that they contain sufficient information. I commend the parties for having reached a settlement with respect to the treatment. Ms. Bordy, did you want to make your statement now?
Thank you, Your Honor. I was having trouble getting off mute quickly enough. We just wanted to note that we did have a reservation of rights with respect to the disclosure statement. We do not have an objection with respect to the disclosure statement. We also thank the debtors and the ad hoc group for working constructively, but at this time we are not resolved, and we may be back in front of Your Honor with respect to the plan and the treatment of the exonic claims. At this time, we are not resolved, and we do not believe that the plan can be confirmed based on the treatment that we've been provided. Thank you, Your Honor.
All right. Okay. All right. Anyone else wish to be heard? All right. So, as I indicated, I do think that the disclosure statement contains sufficient information to go to be set a vote. So, and I think we're on a quick timeline, so we're about 5 weeks out from confirmation. So, Ms. Sinclair, you all filed an order at 2166. Is that the order? Is that order the one you want me to enter?
Yes, Your Honor.
Okay.
Your Honor, I think the only point I would note is that our draft header was also on that order.
Right.
I do think it's appropriate to remove the draft header for purposes of entering the order, understanding that we're all working through the DS itself and the plan.
Got it. Okay. All right. That order has been signed and sent to docketing.
Thank you, Your Honor.
Your Honor, I apologize. Lorenzo Marinuzzi again. One thing I neglected to mention, we have a very short letter urging support for the plan that we'll send to Chambers shortly after this call. It's a letter that you've seen many times, I'm sure.
Yeah, no, and I did notice that there was a specific insert saying that there was a letter. There was going to be a letter from the committee.
We're just waiting for client sign-off. That'll be over to you shortly. Thank you.
All right. All right. For some reason, the other matters today have all been set for 10 o'clock, and I don't know whether it was that originally we all had it set all at 10 and then moved some up to 9, but I don't feel comfortable going forward now on the other matters that are set for 10 o'clock. I know everyone's here already, but... So in connection, for instance, the UCC's motion to expedite, Richard Baker's motion to quash, is that still going forward at 10?
I don't believe so, Your Honor. I'll defer to Mr.
No, Your Honor.
Marinuzzi on that.
Okay.
Your Honor, it's not going forward at 10.
All right. So what we really have at 10 is Mr. Reardon's conditional approval, and I guess the assignment status conference. Those are the two things that are set at 10 that are still going forward. All right. Hold on. Mr. Angelo? I think I just unmuted someone.
Yes, Your Honor. I apologize. I can't actually get onto the camera. This is Jason Angelo from Reed Smith on behalf of Citibank. We're an indenture trustee and collateral agent for certain of the notes. I just wanted to say something on the record. We appreciate very, very much the debtors and ad hoc committee working with us on a variety of changes, much of which has been incorporated into the plan that was filed last night. We'll continue to work with them. Just wanted to note for purposes of establishing a record, there are two roles that we have as collateral agent that we'd like to see added to the definition of pre-petition trustees and agents, and that has to do with the definition in turn of the released parties under the plan. I'm confident that we can work together with Wilkie to resolve that and our other issues, but I just wanted to put that on the record. Otherwise, we have no other objections. As I said, we worked constructively with the team at Wilkie to resolve our informal comments, and we appreciate it.
All right, Ms. Miller?
Your Honor, can you hear me okay?
I can hear you fine, yes.
If it's okay with Your Honor, I'm happy to make the brief update with respect to the status conference now.
Okay, go ahead.
Okay, Your Honor, we still believe we have a deal with the global debtors. We have hit some snags in the definitive documentation process, but we've talked to all the parties. We're all working constructively, and we have commitments to try to resolve it all over the weekend. So, Your Honor, our plan right now is to have a 9019 motion on file for Your Honor's consideration by midday Tuesday. And to the extent that falls through and we don't have it on, we'll just reach out to Your Honor's courtroom deputy to schedule a hearing to move forward on the status conference.
Okay. All right. Sounds good. Yeah. So, all right. So I think what we need to do, unfortunately, is just, go have a cup of coffee and come back at 10, and then we'll pick up
Yes, Your Honor.
with Mr. Reardon at that point.
Thank you, Your Honor.
All right. So
Thank you, Your Honor.
We're in recess till 10 o'clock.